Ladies and gentlemen, good morning. Paris Panthéon-Assas University is very proud to welcome you today in this historic building to kick off this third edition of the France-Singapore Symposium on Law and Business. You are currently sitting in the Grand Amphitheater of La Sorbonne, the former University of Paris. Although the University of Paris was founded in the 13th century, this building you're currently sitting in was built at the end of the 19th century under the direction of Henri-Paul Nénaud, a disciple of Charles Garnier, the architect of the Opéra Garnier that I know some of you visited 2 days ago. This grand amphitheater was inaugurated on the 5th of August, 1889. Since then, countless important lectures have been given where I am standing. Countless prizes have been awarded to students, young doctors, or confirmed professors for their intellectual and scientific achievements. If these walls could talk, they would resonate with knowledge. They would tell you about some critical scientific discoveries which were made in this building or in its vicinity. They would tell you about the major addresses which were made here during important conferences, such as the ones which commemorated the centenary and the bicentenary of the French Civil Code. This building today embodies science and knowledge. It is a testament to the will of humans to always further their understanding of the world and pass on this knowledge to future generations. For those reasons, there could not be a better venue to host the first day of this France-Singapore Symposium, as we're here to ponder on the latest advancements of technology and their resonance in the world. This year's symposium will particularly be centered on artificial intelligence, considering how critical this technology has become in the mere space of a year. As you know, talks about artificial intelligence have been going on for decades. But until quite recently, most of its potential applications still belonged to the realm of fiction. We are suddenly rushed into this new world where anyone can ask on the internet to write a speech. I didn't. To write the code of a program, or the text of a dissertation, or to give an opinion on a legal matter. But thankfully for most of the people in this room, this last capability is still a work in progress. Artificial intelligence can also be deployed to improve the efficiency of organizations or even cities. It can make educated decisions based on a number of parameters that escapes the capabilities of the human brain. All these developments can only raise questions for lawyers as well as for businesses. How are we supposed to leverage this technology? Is it really that efficient and trustworthy? Is the legal landscape sufficiently mature to handle all the questions pertaining to this technology and its needs? These are some of the questions that will be tackled today by leading Singaporean and French experts in their respective fields in 4 different panels. The first panel will deal with the policy coordination and cooperation on technology and AI between Singapore and France. The second will be dedicated to assessing the differences, but also the current common challenges that European and Singaporean data protection laws currently face. The third panel will deal with how AI and modern technologies are transforming the legal landscape. And finally, the last panel will deal with how AI and technology are changing the way businesses operate. This is an exciting program. But before we delve into these fascinating subjects, this symposium will be further introduced to you by more distinguished guests than myself. And for our first distinguished speaker, it will be our host today. It is President Stéphane Braconnier, President of Paris Panthéon-Assas. Stéphane.
Thank you very much. Honorable Chief Justice, respected First President, Madam Senior Parliamentary Secretary of Ministry of Law, and Madam Chair of the Bar Association of Paris, ladies and gentlemen. 11 years ago, in January 2012, Paris Panthéon-Assas University opened its first overseas campus in Singapore. The first classes of the International Business Law LLM were taught to a dozen pioneering students, most of whom were enrolled at that time at the École du Barreau de Paris. Since then, the campus has grown, of course, significantly, and now welcomes every year several dozens of students, both in full-time and continuing education, all of whom wish to master the interconnection of the main legal systems in the business world better. That opening in 2012, which at the time was very innovative for a French university, had a highly symbolic significance for law, universities, and jurists. First, it had symbolic significance for law, which in Southeast Asia is under the dual influence of both civil law, mainly in Indonesia as well as in Vietnam or Cambodia, for example, and that of common law, in particular Malaysia or, of course, in Singapore. Southeast Asia is thus a region with hybrid legal systems whose capacity to adapt to contemporary economic issues and market expectations is probably stronger than anywhere else. However, a good understanding of alternative systems is necessary. That was the objective met by University Paris Panthéon-Assas, the objective set by the Singapore government at the beginning of the 2010s, one of welcoming on its territory a prestigious law university with a civil law tradition, which was a necessity for Singaporean legal professionals as they strive to have a complete understanding or acquire a mastery of alternative legal systems, to be more responsive and efficient in worldwide competition. No legal system exists on its own in the world. Understanding one's legal environment better is undoubtedly one of the main levers of competitive performance. The opening of the campus also had symbolic significance for universities. Expatriating civil law education outside French territory was evidently an imposing task. Implementing that expatriation 20 years ago in the context of an international trade and business context was even less evident, as the Anglo-Saxon law seemed to take precedence. What Paris Panthéon-Assas University accomplished in Singapore and a few years later in Mauritius and today in the Emirates turns the spotlight on the fact that university can be a powerful medium for the interpenetration of laws and, above all, promote a particular legal system at a global level. One can probably not adequately estimate to what extent faculty members, with their education, missions, and high international mobility, contribute to the integration of legal systems and their promotion. The university must have its rightful place and have a fair share in the connection of legal systems, in its contribution to development, as well as to regulation and that of global trade. Lastly, the opening had symbolic significance for jurists, who in the past years have faced new challenges that we had not envisioned when the Singapore campus of Paris Panthéon-Assas University was open. A good understanding of alternative legal systems is no longer sufficient to be able to anticipate economic and professional challenges of these pursuing years, nor of the following months, challenges of digitalization, legal tech, artificial intelligence, the safeguarding and protecting of personal data, and so on. Tomorrow's jurists will have to be not only more adaptive in an increasingly hybrid legal environment, but also be capable of mastering technologies and problematic issues of which we probably know only a tiny part. Being present on several continents allows a university like the one I have the privilege of presiding to be in a better position to apprehend and identify those challenges. And even beyond that, to be able to educate better tomorrow's jurists. The third annual France-Singapore Symposium on Law and Business that I have the honor of opening today in the main auditorium of the Sorbonne, under the gaze of Richelieu, of Robert de Sorbonne, also one of the great French thinkers, Pascal and Descartes in particular, is the place where those challenges are being met, where the stakes are being deciphered, so that France and Singapore will be able to build a fruitful, trusting, and long-lasting relationship in the legal field. I am therefore very happy and also very proud to welcome all the delegates from Singapore, led by the Chief Justice Sundaresh Menon, here in Paris, in this auditorium. Welcome to one of the temples of knowledge, a place where the tradition of knowledge meets the talents of innovation. This symposium owes a lot to those who have made it possible for it to take place and have contributed strongly to its organization. The French embassy in Singapore, of course, and in particular the deputy head of the mission, Mrs. Anne-Denis Blanchardon, who worked in close cooperation with the Singapore Academy of Law teams. The Paris Bar, and especially its Director of International Affairs, Christian Bougerolles. The Ministry of Justice, and of course the members of Paris Panthéon-Assas, who have worked a lot to ensure the symposium's success. In particular, Pierre-Emmanuel Audit, Dean of the Singapore campus, and Mrs. Laosua, who has coordinated its material organization under the supervision of Professor Emmanuel Chevreau. Let me thank you all for your commitment. I would also like to thank Christophe Querero, the rector of the Academy of Paris, who is our host today here in the Sorbonne. Honorable Chief Justice, respected First President, ladies and gentlemen, we all have an important part to play as jurists. We all have an important part to play as jurists, as well as an important role in conveying an understanding of legal systems and the challenges, especially technological ones, which must be faced. I would like to express my hope that this symposium will powerfully contribute to the enrichment of the reflections on those challenges and to the identification of bold answers to the likely difficulties which these challenges will engender. I wish you all an excellent symposium. Thank you very much.
May I now request our most distinguished guest, the Honorable Chief Justice Sundaresh Menon of the Supreme Court of Singapore, to present his opening address for the symposium. Thank you very much.
Good morning. The Honorable First President of the Court of Cassation, Monsieur Christophe Soulard, Senior Parliamentary Secretary of the Ministry of Law of Singapore, Ms. Rahayu Mazam, President of the Paris Panthéon-Assas University, Monsieur Stéphane Braconnier, and President of the Paris Bar, Madame Julie Couturier, distinguished guests, ladies and gentlemen. I'm deeply honored to address you at the third edition of this symposium on the subject of legal systems in a digital age, pursuing the next frontier, and to do so in this historic and simply magnificent venue. It is especially pleasing for me to address you at the Paris Panthéon-Assas University because of the invaluable contribution the university is making in Singapore, as you heard in the thoughtful opening remarks of Monsieur Stéphane Braconnier. And let me say again that my colleagues and I stand ready to support the work of the university in Singapore and in the Asian region. I'm most grateful to the French Embassy in Singapore and the Singapore Academy of Law for organizing this event, and I congratulate them on successfully overseeing the growth of this forum. Some 5 years ago, His Excellency Monsieur Marc Abansur, the then Ambassador of France to Singapore, and I conceived of an event that could bring together key legal and business leaders in France and Singapore to promote collaboration between our respective jurisdictions. Since then, we have held 2 fruitful editions of this symposium, and it has become a significant platform for discussing commercial legal issues of great importance and interest to both our regions. Today, I'm delighted that we're gathering here in Paris for the first time to continue this invaluable conversation. In 1848, the English philosopher John Stuart Mill lamented that technology had yet to relieve the bulk of humanity from a life of drudgery and imprisonment. He envisioned a time when technology would finally effect those great changes in human destiny, which it is in their nature and in their futurity to accomplish. I suggest that today, 175 years later, we are developing a better understanding of Mill's vision because technology is transforming almost every aspect of human life. But what about law? Advances in technology have undoubtedly modernized the practice of law, but they have in many senses not altered the basic workings of our legal systems. Consider the nature of typical legal work and the work of courts. Legal services are still largely delivered by teams of lawyers who are beset with many mundane tasks and who spend much time generating and reviewing ever-increasing quantities of documents. And adjudication is still commonly seen as the main, if not the entire function of judiciaries. But I believe that we are now at an inflection point. We stand on the cusp of radical change in our legal systems, precipitated by new and emerging technologies. My thesis today can be summarized as follows. Technology has clearly begun to transform legal practice and our justice systems, but this will be accelerated dramatically by advances in artificial intelligence, or AI, including those in generative AI that have recently captured our attention. Such change, I propose, is inevitable, and while it will disrupt us, it will also offer many opportunities. Hence, we must embrace this reality and prepare for a future in which technology will pervade our legal systems. To do so, we must urgently examine how we need to overhaul legal practice, legal education, and even our justice systems, so that we may have some chance of not being blindsided by the rapid changes that are upon us. And as we pursue this endeavor, we must remain alive to the risks and implications of these new technologies and ensure that we use these tools in ways that are consistent with the core values of our legal systems. I will develop this thesis in 4 main parts. I will begin by reviewing how technology has already been transforming our legal systems. In particular, I will examine how the rise of new legal products and legal players is changing the very nature of legal services, and how technology is giving rise to a range of new legal issues. Next, I will discuss the rise of generative AI and the profound implications that this will have for those of us in the legal services sector. In the third part of my address, I will explain why we must actively reform our legal systems in response to advances in technology. And finally, I will outline some thoughts on how we should transform legal practice, legal education, and our justice systems in this digital age. So let me begin with an overview of how technology has started to change the face of the legal industry. In recent years, there has been a proliferation of new legal products. These fall into two main categories, namely products aimed at providing substantive law solutions and those that support the management and delivery of legal services. I call the latter of these enabler solutions. Substantive law solutions are tools that provide legal services or actually perform legal tasks. Some of these are targeted at lay users, such as chatbots or virtual assistants that can retrieve and present legal information or even carry out basic legal tasks. For example, in Singapore, our Legal Aid Bureau has developed a chatbot that can provide information on family and civil disputes. It can assess a user's eligibility for legal aid and create simple legal documents. However, most of the substantive law solutions that have been developed thus far have been directed at lawyers. Examples include e-discovery platforms which replace or substantially reduce the manual review of documents, and contract analytics and assembly platforms that expedite the review and generation of contracts. The second type of new legal products are enabler solutions, which include practice and client management software that lawyers can use to streamline processes like billing and help with monitoring deadlines. For example, in Singapore, our Ministry of Law has partnered with Loople, an American legal technology firm, to launch the Legal Technology Platform last year and to promote its broad adoption amongst our lawyers. The Legal Technology Platform is a case management and collaboration platform that allows lawyers to track matters, manage and share documents, and communicate with internal and external teams. Apart from new legal products, advances in legal technology coupled with the actual or de facto liberalization of the legal services sector in several countries are fueling a rise in the diversity of legal players, those who actually participate in the supply of legal services. And this has been driven by the growth of what are referred to as alternative legal service providers, or ALSPs. In general, ALSPs fall into three broad categories. First, there are independent entities such as LegalZoom, which help users create legal documents such as wills and company incorporation materials, or Elevate, which provides consulting, technology, and legal services such as document review to law firms and law departments. The second category of ALSPs comprises the Big Four accounting firms, which have begun to provide legal services in many markets with somewhat different management, structures, and obviously capital than traditional law firms. And finally, there are technology accelerators or incubators that may be linked to law firms. Earlier this year, it was reported that the market for ALSPs had reached $20.6 billion by 2021, which, although still a relatively small proportion of the overall legal services market, had grown at a compound annual growth rate of 20% over the preceding 2 years. These two trends, namely the rise of new products and players in the legal sector, are dramatically changing the nature of legal services in three main ways. First, the definition and organization of legal work is being transformed. In the past, such work was seen as a bespoke, customized service tailored to the individual client and provided end-to-end by lawyers. But as Professor Richard Susskind, one of the world's leading thinkers on technology and the future of the law, has noted, technology is transforming legal work in two closely related ways. It is causing the commodification of legal work, which refers to the replacement of what was once thought to be customized work by standardizable services that can be automated. And technology is driving the disaggregation of legal services into separate tasks, many of which can be and are now being performed by non-lawyers. Take as an easy example the general category of litigation. This can be divided into distinct tasks including advocacy and case strategy, document review and disclosure, project management, and litigation support. While advocacy and strategy remain the province of lawyers, the other tasks can be and are now increasingly being performed by legal technology products or allied legal professionals. Allied legal professionals meaning those who are engaged in the law but are not lawyers themselves. They work with lawyers. The second way in which legal services are changing relates to the type of legal roles that are needed to deliver legal services effectively. This too is a function of some types of tasks being taken over by technology. Thus, technology is replacing the roles of junior lawyers or paralegals who once performed routine tasks like document review. But on the other hand, technology is also creating a demand for new legal roles. For instance, Professor Susskind suggests that two emerging roles are the legal data scientist who will manage and analyze legal data, and the legal knowledge engineer who will translate legal principles and procedures into code. The third way in which legal work is changing relates to the remuneration of lawyers. Since around the mid-70s, the billable hours model has been the default fee structure for legal work. But clients are becoming less willing to pay time-based fees, especially for tasks that can be performed to an acceptable level by technology for a fraction of the cost. This is one aspect of what has been described as the more for less phenomenon, where clients want what they have historically received and more, but are willing to pay less for it. This has a real impact on the economics of legal practice. Law firms have traditionally secured profits by leveraging off a relatively small number of high-value, high-performing partners able to sustain a larger group of junior lawyers. But when clients are no longer willing to pay for the work of the latter and are also not willing to pay more for the services of the former, it will impact the business model directly. I turn to the second impact of technology on the law, namely the emerging legal issues arising from new technologies. This is a vast and complex field, and let me provide just a snapshot using the example of cryptocurrencies and the related issues that have arisen in the Singapore courts. In 2020, the Court of Appeal, our apex court, decided a case concerning the algorithmic trading of cryptocurrency. This raised a number of novel issues, including whether and how the contractual doctrine of unilateral mistake, which allows one party to be excused from a contract if it knows that the other party was operating under a mistake, whether that doctrine applied to a contract made between two computers operating under an algorithm. And we also had to consider whether cryptocurrencies can be regarded as a type of property. And just last year, the General Division of our High Court heard a case about a non-fungible token, or NFT. And this required the court to consider whether the NFT could amount to property for the purpose of granting a proprietary injunction. In both cases, the court had to undertake a detailed review of the technology before it could determine and apply the relevant legal principles. It is clear then that technology has already begun to impact and reshape legal work and has generated a range of new legal issues. But the truth of the matter is we have not approached the many diverse issues and challenges that this will throw up in a systematic way. And to exacerbate the situation, I suggest that our legal systems are now on the cusp of further dramatic transformation arising from recent advances in generative artificial intelligence. In gist, generative artificial intelligence tools are systems that can generate new content such as text, images, and music in response to prompts from users. Perhaps the most widely known example is ChatGPT, a chatbot that seized our attention and our imagination just 5 months ago and had reached 100 million users after its launch in December within 2 months. Specialized generative AI has already been developed for the legal sector. Let me mention 2 examples. The first is a tool called Harvey, which can answer legal queries, summarize information, and prepare drafts of correspondence and documents. Allen & Overy, a leading global law firm, has started using Harvey, and today, up to a quarter of its lawyers use Harvey every day. And PwC, which has become a major ALSP, is rolling out Harvey to its 4,000 legal service professionals and will also develop in-house products based on Harvey. The second example is CoCounsel, a tool created by CaseText, an American legal technology company. This can synthesize different cases to produce a research brief, review and analyze contracts, and even draft questions for the examination of witnesses. Both these products are targeted at lawyers, but tools like ChatGPT are already being used by the public, the lay public, in a legal setting. For example, in Singapore, there has been at least one case in which a layperson used ChatGPT to create court submissions. I will say more about this in a minute. But it seems likely that public demand will spur the development of legal generative AI tools targeted at laypersons as well. I believe these tools will quite rapidly transform our legal systems in two ways. At one level, they will greatly enhance the existing uses of AI in the law in areas like legal research and the production of legal documents. New and emerging generative AI tools are proving to be far better than their predecessors at interpreting user queries and synthesizing complex information. And this will surely be the continuing trajectory in this field. A striking illustration of this is the rapid improvement in ChatGPT's performance in the United States Uniform Bar Exam, or UBE. In December, Professor Daniel Martin Katz, a leading legal technology expert, released a paper that disclosed how ChatGPT 3.5, the AI system that was then powering the prevailing version of ChatGPT at the time, had almost passed the UBE's multiple choice component. Many of us struggle to do that. Barely 4 months later, in March, Professor Katz published a follow-up paper discussing the performance of GPT-4, the latest version of the technology. And according to Professor Katz, GPT-4 can pass and indeed outperform the average human test taker on the multiple choice section of the UBE, and significantly, it can also pass the legal essay and problem-solving components of the paper. I mention this because it indicates the immense potential of generative AI to enhance access to legal information. And I suggest that this opens up many opportunities for the legal sector, including for judiciaries, and I will return to this shortly. Generative AI will also likely result in new ways of using AI in the legal industry. Until recently, the wide consensus was that some aspects of legal work, namely those requiring creativity and emotional or social intelligence, were likely to remain beyond the scope of AI for the foreseeable future. But generative AI tools are already starting to manifest or mimic these capabilities. Many generative AI tools already display remarkable ingenuity and can mimic social intelligence to an uncanny degree. For example, when a user made an inquiry professing to be a passenger on board the Titanic on its final night, Microsoft's Bing chatbot told him to head for the upper deck to find a lifeboat, gave him a map of the lifeboat's locations, and urged him to hurry. And Bing also conveyed realistic empathy with the passenger's predicament. I mention this example because I think it illustrates 2 points. First, generative AI can produce concrete and salient ideas and suggestions. This suggests that beyond generating basic legal documents, generative AI could come to be used even for the performance of what we understand to be primarily creative tasks. Indeed, it has been suggested that generative AI can already be used for brainstorming how to draft unique contracts and other bespoke documents. This could be especially useful for small and medium-sized businesses, which might come to rely on such tools to prepare legal documents. The second point is that generative AI seems to be well on its way to mimicking empathy and emotions, even though the current set of tools is admittedly some distance away from conveying reliable social intelligence, as I shall shortly elaborate. But this possibility raises the prospect that such tools might eventually be able to move out of the back office to take on significant user-facing roles. And this would be a dramatic development, but it is vital that we start thinking about the risks, the benefits, and the implications of such possible uses. Now, all this being said, we have to acknowledge that there remain significant limitations and problems with current generative AI systems. We need to be conscious of these. Let me mention just a few points. First, the dark side of their creativity is that tools like ChatGPT are not bound by values such as honesty and integrity, and they are prone to what are euphemistically called hallucinations. In short, they can give entirely inaccurate or fabricated answers. For example, I'm told that when ChatGPT was asked about the Chief Justice of Singapore, it replied that a former dean of the National University of Singapore Law School had taken over from me as Chief Justice. Perhaps it knows something that I do not know yet. But AI hallucinations are clearly an especially serious problem in the legal context, given the potentially drastic consequences of incorrect legal information. Further, the dangers that inhere in generative AI, exacerbating the pandemic of fake news and the breakdown of truth in modern society, presents real cause for concern. In the same vein, generative AI tools can produce disturbing responses. For example, a New York Times columnist earlier this year reported an unsettling chat with Bing, during which Bing expressed a desire to destroy whatever I want and then claim to be in love with the user. And next, there are intellectual property and data privacy concerns over both the data on which generative AI systems are trained and the information in the prompts that are fed into these tools. This has already sparked litigation and regulatory action. For example, in March, Italy banned ChatGPT before lifting the ban a few weeks ago after the introduction of data privacy protections. And in the legal context, other issues include the concern that entering client data into generative AI might infringe duties of client confidentiality. And then there's the whole question of the intellectual property rights over the generative material. Who owns that? These and other issues explain the recent call by the Future of Life Institute, a non-profit think tank, for a 6-month pause in the development of generative AI, while safety protocols for the use of such tools are devised and implemented. This proposal has been supported by many notable figures, including Elon Musk and other technology luminaries, and it does merit serious consideration. Even more recently, Dr. Geoffrey Hinton, who has been described by some as the godfather of AI, stepped down from his position as Google so that, in his words, he could freely speak about the risks of AI. According to Dr. Hinton, and I do recommend you read the interview, it's extremely enlightening, but according to Dr. Hinton, emerging AI systems are not only very different from human intelligence, but they are much closer to surpassing our capabilities than he had previously anticipated. And to compound these concerns, he points out that generative AI tools are trained on immense troves of information on the internet, much of which may be untrue or inaccurate. And it then processes and interacts with these inaccurate sources in ways we do not understand. He also points out there is a risk that the technology can be manipulated by bad actors, or even that it may develop its own unpredictable, unknowable, incomprehensible pathways. To be sure, these are extremely serious concerns. But the reality, it seems to me, is that as dire as they are, the concerns will not stop generative AI from eventually pervading our societies. And let me make 3 points. First, as Professor Susskind puts it, the existing generative AI systems are the worst they will ever be. Basically, it's only going to get better. It is vital to look not just at where the technology is today, but also at where it is going. And progress is coming rapidly. For example, GPT-4, the AI system that I mentioned earlier, is set to score 40% higher than GPT 3.5 on tests for factual accuracy. Second, generative AI is already so widely used and so deeply embedded in the current zeitgeist that I do not think its rise can be halted. Significantly, technology is now being integrated into widely used products. For example, apart from the Bing search engine, Microsoft now features Copilot, an AI tool for its entire suite of Office applications, including Word, Excel, PowerPoint, Outlook, and Teams. This can apparently draft emails and documents from simple prompts and summarize discussions and propose action items in real time during meetings. As generative AI is incorporated into such products, we must expect that it will become a ubiquitous feature of our everyday lives. And third, the experience of humanity. The experience of humanity has been that we have never shied away from the pursuit of knowledge and innovation because we fear its consequences. Once we have identified problems, our tendency has been to look for solutions rather than to abandon the quest. This spirit has underlain human progress. If those who know much more about generative AI than me say that it may one day pose even an existential threat to humanity, I would believe them. But I don't think this will stop us from exploring its limits, because the human experience tells us that we tend to believe we will find ways to manage the forces that we unleash. But surely we need to proactively respond to the impact, the risks, the implications of these new and emerging technologies. And this leads to my next point, focusing specifically on just the legal context. I suggest that the time has come for us to urgently rethink and reform our legal systems in response to advances in technology. And there are 3 main reasons for this. First, as I've just noted, advances in generative AI are moving swiftly towards mainstream adoption. These innovations will dramatically reshape our societies, including the expectations and aspirations that our people have of and for our legal systems. In a nutshell, technology is transforming the interface between the public and the law in the same way it is affecting the interface between the public and shopping, public and government services in every way. Historically, lawyers have been the exclusive gatekeepers to legal knowledge and expertise. But as technology expands access to legal information, the public will increasingly use and expect to use digital tools to access the law. Such tools will therefore increasingly act as the intermediaries between citizens and the law in a growing number of contexts. This has major implications for our legal systems, and we must face up to them and adapt, or risk becoming overwhelmed. Second, advances in technology offer tremendous opportunities for our legal systems. And there are 2 aspects to this. From the perspective of lawyers, technology can greatly enhance the efficiency and quality of work by taking on tedious tasks. The countless hours that junior lawyers would once have spent reviewing documents can now be better invested if a significant part of that is delegated to e-discovery software. But beyond this, at a systemic level, technology can greatly enhance our legal systems. It can significantly advance access to justice, and this must be a key priority for our justice systems. I will elaborate on how our courts can deploy technology to promote this goal shortly. Second, technology will be crucial to addressing new challenges that arise from advances in technology. One example is evidential complexity, which refers to the massive quantity of evidence that is now being created, stored, and then ventilated during litigation. Again, e-discovery software may be able to help us address this problem by rapidly sifting through the material and identifying or even accurately summarizing the relevant information. This suggests that technology can play a key part in solving some of the problems that it generates. And that brings me to the third reason why we must urgently reshape our legal systems. Technological advances carry various risks and implications, which we must examine and address swiftly. For instance, I've just noted that technology will take away some of the work of our junior lawyers. But how are we going to train the junior lawyers if they don't have that basic work to be trained on? So we will have to find new ways to imbue junior lawyers with forensic or other legal skills, because much of their early formative work becomes mechanized. And as I've mentioned earlier, generative AI raises serious issues that have to be confronted, considered, and addressed. Again, one example, we have already encountered a case in Singapore where a self-represented person used ChatGPT to create submissions that included entirely fabricated case law. It was very convincingly presented, it was all false. This suggests the need for governance, as I've just mentioned, so that we can develop policies on the use of generative AI and perhaps also tools that can detect the misuse of such technology. Some first steps have already been made on this front. In Europe, the proposed Artificial Intelligence Act will establish a comprehensive framework governing the use of AI. And this will involve a risk-based regime under which different regulations will apply to different categories of AI that are differentiated based on the degree of risk that they pose to society. While these are encouraging steps, there is much to be said for a coordinated worldwide approach because of the global reach of the problem. In this regard, it has been suggested that an international agency for artificial intelligence should be formed to develop governance and technical solutions to promote the safe and secure use of AI. These are big issues, but amidst these manifold challenges, it is critical that we urgently reshape our legal systems, narrowing down to the specific point that we are concerned with to respond to our dramatically changing landscape. And in that spirit, let me propose some ideas on how we might pursue this endeavor. I start with legal practice. I noted earlier that technology is transforming the interface between the public and the law. And I suggest that this will affect demand for legal services and thereby change legal practice in at least three ways. First, there will be increasing demand for generative AI and other digital tools that can help laypersons solve or resolve basic legal issues or problems without a lawyer. As I noted earlier, small businesses will likely come to use generative AI tools to prepare many legal documents. Legal service providers will therefore be called upon to develop digital tools to meet this growing demand. Second, and conversely, there will be significantly reduced demand for lawyers to provide basic legal services that can be adequately performed by digital tools. The value proposition of lawyers will lie in the complex legal work that cannot be effectively provided by technology. And third, clients will increasingly expect legal service providers to use technology to provide legal services efficiently. Law firms will thus have to incorporate digital tools into their work processes. With this in mind, the reform of legal practice, I suggest, should focus on three areas: the organization, remuneration, and regulation of legal service providers. In relation to the organization of legal service providers, I focus on law firms, and I suggest that their models and compositions will come under considerable pressure to change. Law firms have traditionally been organized in a pyramid model with a small group of senior partners supported by a broad base of associates and paralegals. This reflects the traditional leveraged approach to law firm profitability that I mentioned. But as technology takes over routine tasks and is increasingly integrated into the workflows of law firms, many entry-level positions will fall away and new roles in legal technology and other areas like project management will emerge. Law firms should therefore rethink their hiring and organizational practices. They will likely need to recruit both legally trained professionals with expertise in technology, whom I will call legal technologists, as well as a core of allied legal professionals with skills in data analysis, design thinking, and other areas. And we can expect that legal technologists will work with allied legal professionals and other lawyers in multidisciplinary teams to create, use, and develop legal technology products. And this might lead law firms to evolve from a pyramid structure to one that more resembles what has been described as a rocket, with a narrow core of digitally savvy lawyers flanked by legal technologists and allied legal professionals. In other words, it will be a multidisciplinary setup. Turning to remuneration, law firms and their clients should recognize that the business model will likely have to change. On the one hand, legal service providers should harness technology to offer alternative pricing structures. This could involve fixed-fee arrangements or freemium models under which basic legal services are provided without charge, generally through the use of chatbots or virtual assistants, while fees for bespoke services are tied to specific deliverables. But the complexity of legal work and the growing complexity of legal work will call for lawyers who have deep and diverse skills. And those lawyers will have to be paid at a level that reflects those expectations. This wouldn't necessarily mean higher costs for clients, because a lot more will be able to be done without the involvement of lawyers. But there is plainly a need for honest discussions in this context. And finally, it'll be critical to consider the need to regulate legal service providers, especially certain types of ALSPs. A central issue relates to the types of services that ALSPs should be allowed to provide. Should legal chatbots be allowed to provide legal advice beyond just legal information? And if so, who should be liable for incorrect advice? There are certain services like judicial analytics which France banned in 2019. And are these consistent with core values of our legal system, such as judicial independence? We must consider such issues before the technology overtakes us. The real danger that we face is that we sleepwalk into the future, not having thought about the issues that are coming upon us. Let me turn to legal education. As Professor Susskind suggests, the starting point is to consider what we are training the next generation to become. I've just outlined how technology might transform legal practice, and we must equip future lawyers to succeed in that emerging reality. This suggests the need to fundamentally rethink both basic and continuing legal education for lawyers and to develop courses and programs to train allied legal professionals. In relation to basic legal education, I suggest that law schools should arm all their students with essential technology-related skills and knowledge and develop law and technology programs. This will meet the anticipated industry demand for digitally literate lawyers and create a pipeline of legal technologists. In the quest to impart basic digital legal practice skills to their students, law schools could expose students to e-discovery, contract automation tools, legal analytics, and data security issues. Law schools should also familiarize students with data-oriented and design thinking as well as mindset understanding, which refers to the knowledge of the mental frameworks of technologists. This will enable the next generation of lawyers to work more effectively with legal technologists and allied legal professionals. And law schools should expose law students to emerging trends in legal services so that they are sensitized to the diverse ways in which the legal market is actually evolving. And law schools should transmit broader technology-related knowledge to their students. Law students should be acquainted with the basic workings of new technologies like cryptocurrency and AI systems so that they can start to appreciate and consider the legal issues that these will give rise to. And law schools should also consider collaborating with other university departments to offer courses in digital ethics and regulation and to apprise their students of the complex normative issues that will arise from these technologies. There is also a need for joint law and technology programs to help form and equip a future generation of legal technologists. For example, the Singapore Management University offers a Bachelor of Science degree in computing and law, and recently introduced 3 optional specialist tracks for law students, including one in law and technology. Such programs will be a vital part of the effort to develop a pipeline of digitally savvy lawyers and legal technologists who can interface effectively between clients, lawyers, and allied legal professionals. And that brings me to continuing legal education, or CLE. While this has existed for some decades, its importance will increase sharply in view of what has been called the decreasing half-life of knowledge. This refers to the diminishing span of time that it takes for knowledge to be superseded, either because it is shown to be untrue or because it is irrelevant, given advances in science and technology. This reality requires us to fundamentally rethink our relationships with our universities and how we expect to be equipped when we finish our initial studies. There was a time, certainly in my time, when we graduated thinking that we were armed with a body of knowledge that we could monetize over the course of a career. That simply cannot be our mindset today. Instead, graduation should mark the beginning of a lifelong relationship underpinned by a continued commitment to learning, because much of what we know or think we know when we graduate will become irrelevant or freely available much more rapidly than before. Our basic university education should therefore be geared towards teaching us the skills needed to make us effective lifelong learners. CLE will be indispensable to ensure that lawyers can acquire and develop new skills and knowledge throughout their careers. This is especially pressing in relation to technology, where the advances are increasing in pace and complexity. There have been moves to enhance technology-centric CLE in parts of the US, where lawyers, for instance, in Florida, North Carolina, and New York, are now required to attend a modest number of hours of technology-related CLE. These are steps in the right direction, but they are modest, and much more will surely be needed to be done to equip lawyers to deal with rapidly changing areas of the law and legal practice. And then there is the whole subject of the education of the allied legal professionals, who will play an increasingly important role in the legal market. Legal education providers should develop a variety of courses and certification programs covering both substantive topics like data science and project management and functional topics like e-discovery, so that we can develop a supply of allied legal professionals with practice-oriented skills. And they can then pursue different pathways in law firms or in alternative legal service providers. And I turn finally to our justice systems. I suggest that it is time for courts to embrace technology in their mainstream work for at least two reasons. First, we must respond to the changing expectations of the public, who will increasingly demand that we deploy technology in the delivery of justice. And second, adopting digital tools will be key to addressing the profound problem of inadequate access to justice. The enormity of the challenge of access to justice was captured by a 2019 study conducted by the World Justice Project, which estimated that 1.4 billion people face barriers to justice in civil and administrative law matters. We tend to assess the health of our justice systems by reference to how well or how poorly we deal with the cases that reach the courts. But I suggest this creates a big blind spot, because rather like an iceberg, the cases that reach the courts represent a small part of the full scale of the justice problem. We must therefore strive to improve access to justice, and technology has immense potential to help us achieve this. I suggest that we should adopt two main strategies. We should harness technology to assist our users to navigate our justice systems, help them work their way through our justice systems to access the information that is there. And secondly, we should consider the use of technology to support adjudicative work in certain limited contexts. Taking the first point, our courts should use technology to help our users traverse the justice system. And this will require us to reimagine the judicial role. Traditionally, the judicial role was understood almost exclusively in terms of adjudication. The parties bring the evidence, the documents, the judges decide the case. But if we reflect on the judicial mission, which is to deliver justice, it becomes plain, I suggest, that our courts also have an assistive duty to help our users access and navigate our justice systems. This is because the journey to justice can be arduous and alien for many court users, especially self-represented persons who comprise an ever-increasing portion of our court users. And if we do not help them, many will leave empty-handed. This would both thwart the mission of our courts and also corrode the legitimacy of our justice systems. I therefore propose that our judiciaries adopt the model of what has been referred to as the extended court. On this model, apart from adjudicating disputes, courts should assist their users to understand legal information and facilitate their journey through the justice system. This does not mean courts provide legal advice, but they should offer legal information and assistance. Technology can help the courts deliver granular and salient legal information to court users. Let me give you an example. The Singapore courts collaborated with the Singapore Academy of Law to develop a motor accidents claims online simulator, or MACO, which we launched in October 2020. This is a free online tool that allows the parties involved in a traffic accident to get information about their likely liabilities, the likely amount of compensation that would be ordered for personal injuries, and so on. So far in the year and a bit that the system has been in place, we've had more than 13,000 simulations. People have gone in to access the system to get an idea. Our judiciary is also exploring the use of chatbots to deliver information about court procedures, as well as text-generative AI, which seems to have real potential to provide pertinent legal information. The second way that we can use technology is by developing tools that can generate court documents for use by litigants. Again, let me provide an outline of the progress that we've made. In 2018, the Community Justice Centre, which is supported by the Singapore Judiciary, launched the Automated Court Documents Assembly tool. This can be used by laypersons to prepare documents for bankruptcy and deputyship applications, as well as mitigation pleas in criminal cases. In November 2021, we launched the Divorce e-Service, which is an electronic platform that laypersons can use to generate and file the documents needed for divorce cases. And more recently, we launched a probate e-service just this April, which enables an executor named in a will to apply for probate within minutes. Now, these tools will cover the vast majority of cases, not all, because there will always be complex cases that will need to be dealt with through legal advice. But there's no need to impose that requirement for every single one of these instances. The second way in which our courts might come to use technology to enhance access to justice is in the realm of adjudication. And let me briefly outline how AI has already been used in criminal cases. Now, there are concerns over some of the existing uses of AI in criminal justice, and this will need to be very carefully considered. But it has been used so far in two main ways. First, to assess a person's risk of recidivism in the context of bail or parole and sentencing decisions, a leading example being the Compass tool, which is used in the US. And second, it has been used to generate sentencing recommendations for crime judges in Malaysia. There are three principal concerns that have been raised over the use of such tools in criminal adjudication. The first is the bias objection. Existing tools for criminal justice are trained on data that often reflect ethnic, racial, and other biases, and this undermines their reliability. And courts may also infringe fundamental principles of equality if they rely indirectly on patterns that encompass these biases. The second objection concerns opacity, or the inability to understand the system. Many AI tools are opaque because the algorithms and the underlying data sets are not disclosed, and the code is impenetrable to laymen, and there is no complete way to explain their output. This is problematic for several reasons. A central concern in the justice context is that such opacity reduces the intelligibility of decisions. Judges may not understand or be able to adequately explain the logic of a tool. The third objection is what we call the humanity objection. In criminal adjudication, courts may deprive offenders of their liberty and impose other onerous sanctions. In this light, many of us share a deep conviction that criminal adjudication should be entrusted to and left under the control of humans who share our moral outlook, methods of reasoning, and the gift of exercising an appropriate degree of empathy in a given case. For these reasons, the Singapore courts are unlikely to adopt AI tools in criminal adjudication in the foreseeable future, but we will continue to study the field and monitor developments elsewhere. But these objections do not apply to at least some types of civil cases. Consider simple civil cases that do not require significant normative judgment, but involve largely arithmetical issues that can be appropriately resolved through the application of common platforms. For example, maintenance applications in family proceedings. In this context, the humanity objection might either not apply because there's no significant hardship, or it might be adequately met if the algorithmic output can be validated by a human judge. Similarly, the opacity concern may have less force if the relevant algorithms are simple, publicly available, and can produce brief reasons. And the bias objection may be mitigated over time by refining the data sets. We are therefore continuing to study the possible use of AI to support adjudication in such simple civil cases. Existing AI models can identify an appropriate outcome in such cases with reasonable reliability, and this could both speed up the process and lower the cost of dispute resolution, and that would free up judicial resources that can then be channeled to other more complex cases, thus enhancing access to justice. Ladies and gentlemen, I want to conclude by returning to where I began, Mill's vision. 175 years have passed since Mill's lament, and much has changed in the world since then. But our legal systems still await the monumental changes that Mill envisioned. My suggestion to you today has been that technology is about to force that change and to transform many aspects of our lives, and this will inevitably present serious challenges to our legal systems. In that light, I suggest we should look ahead, anticipate the issues, imagine the possible solutions, and harness the power of technology intentionally so that we make our legal systems better equipped to meet the future. I've sought to start the conversation with some suggestions. I look forward to learning of your views over the course of this symposium. These are profoundly important issues, and they're also fascinating, complex, and difficult. We must therefore apply our best talent collaboratively to addressing them. In the same spirit, let me mention another forum which promises to be an invaluable platform for exchanging ideas on law and technology, and this is the Tech Law Fest 2023, one of the world's premier law and technology conferences, which will be held in Singapore in September, and which will examine cutting-edge issues at the intersection between law and technology. I hope many of you will make it there. Thank you so very much for your attention, and I wish you a very fruitful symposium. Thank you.
Thank you so much, Your Lordship, for those extremely thoughtful remarks. My only concern is that everything was so well said that what are we going to talk about during the rest of the symposium? Thank you very much. May I now invite the first president of the Cour de Cassation, Mr. Christophe Soulard, to present his opening address to the audience.
Monsieur le Président de la Cour suprême de Singapour, Monsieur le Président de l'Université Paris 2 Panthéon-Assas, Madame la bâtonnière, Madame l'ambassadrice, Madame la représentante du ministère de la Justice, Mesdames et Messieurs, c'est un honneur et un plaisir pour moi de participer à l'ouverture de ce symposium franco-singapourien co-organisé par la Singapore Academy of Law, le barreau de Paris, et qui illustre l'exceptionnelle coopération entre Singapour et la France. Depuis 2005, cette coopération ne cesse de s'enrichir. Elle rend possible l'échange autour de thèmes dont l'actualité est pressante. L'open data, la protection des données, l'utilisation de l'intelligence artificielle et des technologies sont autant de sujets qui soulèvent des enjeux fondamentaux et transversaux. En matière commerciale, de recherche, de propriété intellectuelle et industrielle. Cette mutation technologique et sociétale intéresse tant les juridictions nationales que les institutions européennes et internationales et la société civile. Cela justifie bien entendu que l'on s'en saisisse. Au sein de l'institution judiciaire, ces enjeux se cristallisent notamment autour de la diffusion des décisions de justice. L'intégration des technologies au sein de la sphère judiciaire représente un défi juridique et technique majeur pour le pouvoir normatif et judiciaire. Monsieur le Président de la Cour suprême de Singapour vient d'en donner évidemment un certain nombre d'illustrations et de noter ces enjeux. Ils sont source potentielle de grande efficacité, de gain de temps. Ils participent à diffuser et approfondir le savoir dans les sciences juridiques. Il est tentant d'y voir la promesse qu'elles viennent pallier les problèmes de la justice, si souvent décriés dans la presse, son accessibilité, sa lenteur, son coût. Toutefois, ces nouvelles technologies et l'usage qui en est fait peuvent mettre en jeu certains droits et libertés individuelles protégés au plus haut niveau dans nos démocraties. Il est donc primordial que l'ensemble des acteurs juridiques et politiques se saisissent de ces sujets. Universitaires, avocats, magistrats, administrateurs, politiques, tous sont concernés. C'est pourquoi je me réjouis que ce symposium réunisse autant d'acteurs divers pour échanger sur ces thématiques. L'open data des décisions de justice s'intègre dans un mouvement général de modernisation de l'action publique qui vise à garantir la transparence de celle-ci et à offrir à tous la possibilité d'exploiter ces données dans l'intérêt collectif. Plus précisément, l'open data des décisions de justice permet la mise à disposition sous format électronique et à titre gratuit des décisions de justice et permet leur réutilisation par le public. On y retrouve bien sûr les systèmes algorithmiques qui vont avoir plusieurs rôles ici, moteurs de recherche, modélisation statistique sur des sujets précis ou identification de critères de décision à travers l'utilisation de l'intelligence artificielle. Parler de la Cour de cassation et de l'open data, cela peut a priori étonner. La plus haute juridiction française, vieille de 233 ans, semble à première vue bien loin de la Silicon Valley et de la French Tech. Et pourtant, conscient des enjeux juridiques majeurs soulevés par ces nouvelles technologies, le législateur et les juges français se penchent sur la question de manière sérieuse et active. La diffusion numérique a d'abord vu le jour en 2005 avec un instrument que nous appelons Jurinet, qui est une base de données commune aux décisions et avis de la Cour de cassation et à certaines décisions sélectionnées des juges du fond. Le partage restait alors interne à l'institution judiciaire. Puis en 2008, la base de données Jurica a permis, toujours de manière interne à l'institution, de partager également la jurisprudence des cours d'appel en matière civile, sociale et commerciale. Dans un second temps, les décisions ont connu une diffusion au-delà de l'institution judiciaire grâce au site Légifrance. La diffusion, qui était initialement sélective, est progressivement devenue exhaustive. Et bien entendu, il a fallu instituer un cadre législatif à ce processus d'ouverture qui tend vers l'exhaustivité. Les premiers textes en ce sens remontent à 2016 avec la loi pour une République numérique. Les objectifs poursuivis par le législateur sont de trois ordres. D'abord, garantir l'exhaustivité des données des décisions. Ensuite, permettre une meilleure connaissance des décisions des juridictions et donc une meilleure prévisibilité du droit applicable avec une anticipation des risques contentieux. Enfin, accroître la transparence, la connaissance et le savoir des citoyens dans l'objectif de renforcer leur confiance dans la justice. Un décret de 2030 a confié à la Cour de cassation, pour ce qui concerne les décisions judiciaires, et au Conseil d'État, pour ce qui concerne les décisions administratives, la responsabilité de la mise en œuvre de cette diffusion massive des décisions. Ce n'est pas par hasard si on a confié aux deux juridictions suprêmes cette responsabilité, car c'est le signe de ce que des enjeux en termes de liberté fondamentale sont ici présents. Dans ce cadre, les décisions de la Cour de cassation étaient mises en ligne le 1er octobre 2021. Quelques mois plus tard, c'était autour de la plupart des arrêts des cours d'appel. Et nous sommes maintenant dans la mise en ligne de l'ensemble des décisions des tribunaux. Nous commençons par un échantillon de tribunaux et puis très rapidement, puisque tout cela doit se faire avant 2025, nous allons mettre en ligne l'ensemble des décisions rendues en France en matière civile, puis plus tard en matière pénale. Si on veut se rendre compte de l'envergure de la tâche, il faut noter qu'avant l'open data, environ 15 000 décisions étaient diffusées chaque année sur le site Legifrance et qu'avec l'open data, ce seront 3 millions de décisions par an qui devront être mises en ligne. C'est donc une multiplication par 200. La diffusion des décisions de justice, grâce à l'intégration de l'open data, constitue donc une ouverture nouvelle et large. Elle traduit la volonté de la France de s'inscrire dans le mouvement global d'ouverture des données publiques. Mais il y a une singularité des données judiciaires qui, en raison de leurs sources et de leur objet, en raison des droits des justiciables. L'open data ouvre des perspectives stimulantes, sinon vertigineuses, et on était pris parfois de vertige en écoutant le Chief Justice, quant aux évolutions de la jurisprudence qu'elle peut induire, et donc il engendre des risques. 3 en particulier intéressent la Cour de cassation, je vais les évoquer très rapidement, la Cour de cassation et plus généralement l'ordre judiciaire. Le premier risque, à mes yeux, est celui d'un nivellement des décisions de justice. Au vu de la masse informe que représente l'open data, l'objectif ne se limite pas seulement à disposer d'un nombre accru de décisions. Il faut identifier le statut qui doit être conféré à chacune décision. En tant que juridiction suprême de l'ordre judiciaire, la Cour de cassation est particulièrement vigilante quant à l'intérêt particulier que les décisions des juridictions du fond se voient hiérarchisées. On ne peut pas aborder de la même manière un jugement d'un tribunal judiciaire et un arrêt de la Cour de cassation, ou, parmi les arrêts de la Cour de cassation, un arrêt d'espèce ou un arrêt de principe. Il y a donc un travail de hiérarchisation à accomplir. Et c'est dans ce contexte et dans le contexte de la dématérialisation des bulletins de la Cour de cassation qu'il a été décidé de faire évoluer la classification et la hiérarchisation des arrêts de cette Cour. Le deuxième risque lié à l'open data est celui d'un appauvrissement de la créativité juridique. Le traitement algorithmique des décisions de justice fait apparaître des récurrences et des régularités dans la manière de juger. Il peut donc favoriser, consciemment ou inconsciemment, des tendances conformistes dans l'application des règles de droit. Le risque serait donc que la jurisprudence se fige et s'atrophie en se découplant de l'évolution des normes et des valeurs. Pour éviter cela, il est essentiel de préserver la créativité du juge et la vitalité du raisonnement juridique. Le troisième risque concerne les droits fondamentaux, notamment le droit à un procès équitable, entendu au sens large, mais également la protection des données à caractère personnel, le respect de la vie privée et la non-discrimination. Ces questions sont souvent soulevées par des chercheurs inquiets de la possibilité d'une justice déshumanisée où un algorithme viendrait rendre décision à la place des magistrats. Les algorithmes, ça a été dit tout à l'heure, ne répondent pas aux mêmes impératifs de transparence et de neutralité. Contrairement aux juges et à l'avocat, ils n'ont pas de déontologie. Il est donc essentiel de veiller à une utilisation appropriée de ces outils et de réfléchir à leur encadrement afin d'assurer la conformité des outils aux principes érigés pour une bonne administration de la justice. Cette réflexion que nous devons avoir, c'est une réflexion donc autour de l'intégration et de l'encadrement des nouvelles technologies, ne se borne pas aux frontières d'un pays. Il incombe aux institutions européennes et internationales d'œuvrer pour cela afin de créer un cadre normatif harmonisé et de protéger les droits et libertés qu'ils garantissent. La position de la Cour de cassation est donc à la fois prudente et enthousiaste. Elle considère que l'open data des décisions, judicieusement pensées et encadrées, peut renforcer la sécurité juridique et améliorer le développement du droit, pour peu que soient mises en œuvre quelques adaptations du droit positif et l'adoption de pratiques adéquates. En raison de leur caractère transversal, ces questions doivent faire l'objet d'une approche protéiforme, multidirectionnelle. Aucun pays, aucune juridiction ne peut se contenter de chercher les solutions uniquement en interne. Nous avons au contraire beaucoup à apprendre des autres sphères et cultures juridiques. Ce symposium offre une opportunité précieuse à cet égard pour échanger, pour approfondir nos connaissances quant au phénomène de l'open data et de manière générale de l'intelligence artificielle et des nouvelles technologies. En réunissant avocats, magistrats, universitaires, politiques et autres personnes intéressées, tant françaises que singapouriennes, il promet d'être particulièrement fructueux. Et c'est donc, encore une fois, je le répète, avec un très grand plaisir et un grand honneur que je participe à l'ouverture de ce symposium. Merci.
Thank you very much, Mr. President, for your precious remarks on the potential and risks of open data and algorithm in the field of justice. We are going to take a short 5-minute break and we'll be back. Thank you very much.